Record, I'm the Honorable Dan Itse, no longer representative. I live in Milford, New Hampshire, and I do rise against the bill. The legislation you have before you has all of the same flaws that House Bill 687 had. You can only require a hearing in regard to a temporary order if that order is issued in written form. If it's issued telephonically, you have no power to require that initial hearing. As you've heard others testify, if you have your firearms taken away, there's no onus on the confiscating authority to maintain the condition of those firearms, or any other property for that matter. And if you wish to regain that property, it would require going to court and proving that you were competent to do so, which would cost you tens of thousands of dollars. So it has all the same warts that 687 does. In addition to that, I too have a mother-in-law who suffered from early dementia, and I have a brother-in-law who is Down syndrome, and as you all may know, or many of you know, I had a disabled son whom I cared for many years. My mother-in-law imagined abuse by family members frequently in her last couple of years, and they were imagined. She returned home from a wedding early. My brother-in-law was still down at the wedding. She refused to call him to ask him how to turn the air conditioner on, but then alleged to all her friends that he would not allow her to use the air conditioner. Okay. People who are of compromised mental capacity are not in a position to make reliable allegations. My brother-in-law could never execute such an action. But I'm going to bring it to my son. One of the biggest dangers you would have is somebody who's caring for an elderly or a disabled family member in the home. They have nursing coming in. When Jared was about 5 years old, we had a nurse who came in and disagreed with some of the methods by which we were caring for Jared. She told my wife and I that she was going to file child abuse charges against us because she thought he should have a particular surgery that we chose not to have. Believe you me, we worried about that for quite a while, but we also quickly removed her from the home. There is no investigating authority in this legislation. You're entering a really thorny issue. You are, as you know, I sat on Children and Family Law for 16 of my 18 years here. And one of the things that was particular about that committee was everything we dealt with was inside the castle walls. If a man's home is his castle, the state has to tread very carefully, and there must be investigation before action is taken. I'd be happy to take any questions.
Any questions? Representative Burke.
Thank you, Madam Chairman. Could you show me in the bill where there is, once an order is placed, that the person is going to get help?
Again, there is none. You actually have, there is a correlating statute to this. We already have a, in one of the, I think it's 173? I'm not sure. But there's another chapter protecting disabled adults having to do primarily with in facilities. And this could be, this kind of concept could be folded into there, where DCYF is the investigating authority, and if a complaint is made, they have to go in, do all the same protocols, they have the same rules of evidence that they would have in a child protective case, and go through in an ordered manner and find out what's really happening before the state takes action.
Thank you.
Thank you.
Thank you. Representative Beer?
Yes. Would you consider an issue, my understanding is that DCYF, when they actually investigate a claim of abuse, if someone answers the door, and it could be the person who's the abuser, and decides not to let them in, then DCYF can't go in. So, in your opinion,
As the author of that particular issue, what it actually says, they can't go in unless they have a court order to go in. If they have a court order to go in, that is the same thing as having a search warrant. You've had independent eyes on the situation. A judicial authority has said, yes, there is cause to go in, and yes, you can, and yes, they can go in if they get a court order to do so.
Lola?
isn't that the situation in this bill? Wouldn't a judicial authority be making a ruling that it's okay
There's
to
an
actually go in and see what's going on?
No, that's not the way the bill is crafted. The bill is crafted that if you get an ex parte order actually violates Part 1, Article 15 of our Constitution, which says before somebody can be punished, okay, having your property confiscating, being deprived of your abode is punishment. You can't be deprived of your property or held to account for any crime or offense, and it's important that they say offense, unless it is first completely explained to you. There's actually, it says it about 3 or 4 different ways. They wanted to make sure that those of us in government knew what it meant to explain something to somebody. But they can't go in until, you can't be held account for an offense until it is completely and fully described to you. And that can't happen in an ex parte situation because you don't even know that the issue exists. Now, could they, in an ex parte situation, get an order to go in and look? Yes, of course they could. You don't necessarily know about a search warrant before it's been issued. That happens ex parte.
Thank you. Thank you, Senator Peters.
Croc TV.